that the national government and the county governments can actually impose the same charges on the people in terms of tax. If you look at 2094, because it says the county government, the national and county government may impose charges for the services they provide if they provide the same service, almost the same service. For instance, if you look at betting, betting is both betting is licensed by the national government, but also by the county. So can both the national and county government impose tax with respect to that?
Okay, thank you, Commissioner. This article is meant to be read together with the schedule that demarcates or allocates function between the two levels of government. That particular schedule doesn't envision overlaps. So if the national government has a mandate on certain area and county government may not necessarily concurrent, may not have an obligation on that, cannot impose a tax on that. There is a national economic policy that county government are bound by in terms of imposition of any charges and taxes. But strictly, that would be ultra-vires going beyond their power if county government would actually reach out for a mandate that is for the national government, or national government reach out in terms of charging the service, providing for it and charging the service. One thing is that you cannot impose any of this without a legislation. It says by law.
But if you look at 4, it says the national government and county government. It does not separate. It puts them together. May impose charges for the services they provide. What if these services are the same or almost the same? So can both the national government and county through legislation?
Yes. Can they both?
Yes.
Now, there are instances where national government is given a certain function, and also county government is given an element to the extent that it's within the confines of the county. Now, there are discussions around these issues of double taxation and cross-border issues. Cross-county boundary taxation.
Yes. Yeah.
And there's a law that has been enacted, I think 2024 Act in County Licensing, that is Procedures Act, that brings about the discussion around when any of the counties can impose a tax, even when the other entity or whoever has obtained a permit or a license is operating cross-border. So there is that mutual recognition and so on. But when it gets to national government, the national policy has indicated the mandate of county government is retained by county government and national government for purposes of taxation and avoiding making it complex to do business in Kenya. It is actually a big issue in terms of the relationship between and amongst county. And what has happened, there's a lot of reform going on in that sector, including having single permit for certain transactions in certain counties, tested in Murang'a, in Mombasa, Nairobi as well. It's a going concern. It's a issue.
Yeah. For instance, if you look at Kwale, if a product, for instance, is extracted from Kwale, and there is a requirement that cess is paid by Kwale, then that product is delivered to Mombasa as the final port. Can both counties tax for the same?
Yeah, the law does not stop them from taxing for the same incidental. Even that base titanium case, I guess is the one you're making reference to, allows for that. I think what we need is a law, an act from the Senate that will allow for mutual recognition and how they share revenue out of that.
So do we have one?
That County Licensing Procedures Act.
Do we have a national law that now regulates cross-county taxation?
Yes. Still matter for consideration. The Manufacturers Association, KMA, I think, is working on it together with the county government to come up with a comprehensive legislation that would allow for ease of doing business in the Republic, with that in mind.
Okay.
Thank you.
Thank you. That's all.
Thank you, Justice Chair.
Thank you, Honorable Chair. Ms. Muthaura, I wish you can place the microphone closer to... so that we can hear you properly.
Okay, all right. Sorry,
Yeah.
Commissioner.
And raise your voice.
Okay,
Okay. We were actually struggling to hear you,
okay.
but I
Sorry.
think it will be better now.
My apologies.
I want to give you a hypothetical case. An investigator from the Ethics and Anti-Corruption Commission is investigating unlawful allocation of land, and there is a suspect. Let's call him Mr. X. And so this investigator calls Mr. X and they arrange for a meeting. And in the course of the meeting, the investigator reveals why the meeting is taking place. And he suggests to him that if he is given some bribe money, he will ensure that that file is closed. This matter is before your court, and the evidence that is being tendered is that this investigator induced this suspect to give him, or this accused person now, to give him the bribe money. How do you think you will handle that matter?
Mm-hmm. Okay, thank you, my lady, Commissioner. Suspect X meets up with an investigation officer from EACC. The investigation officer requests that if he's bribed, the file will be closed.
Yes.
And now we have X in court as an accused person for the unlawful matters relating to land. And his defense is that he was induced into giving the bribe. Is the offense about the land or is the offense about the bribe? Commissioner, sorry, clarification.
The offense is about, it's a criminal trial of giving out a bribe.
Good. Okay. Did the money exchange hand? Yes or no? If
the money exchanged hands.
Exactly. So if the money exchanged hand, there is the the offense of bribery involves both the giver and the taker. At the point when that offer was made to X, he ought to have immediately taken certain action requiring that this is an illegality and probably reporting the same and not giving the bribe.
Please speak closer to the mic.
Yes.
Just bring the mic at the window.
Okay. Yes. So the bribe, if it's changed hands, as indicated, X offered the investigation officer the amount, so he is actually on the wrong to have given the bribe himself. So both the giver and the taker are bound, unless he did disclose at that particular moment and report that this is an inducement that made him compelled, and still doesn't take away the offense of bribery from the point of X in that case.
I like the fact that you're using correct words, that before X is charged in court, he's a suspect, and once he's in court, he's an accused person.
Mm-hmm.
That your analysis is correct to that extent, but does it matter whether X gave out the money, given the fact that this was an inducement and the investigator wanted to receive that money so that he can use it in court as evidence?
Okay, the money may not even have changed hands.
The money changed hands.
Then that is in itself is a conclusive evidence that is involved in the offense of bribery.
This is why I was asking you, does it matter that this money was paid following an inducement?
That's a defense that he is applying to probably to show.
You're fading off.
Yes, it's a defense that is applying to show that he did not play a role in the entire bribery act. For me, he did participate in it. Whether induced or not, you should be able to say no. And even the law actually provides that when induced, you should take certain action. not necessarily complying, then seeking to run away from the act of engaging in
So
crime.
you would convict X?
Yes, for the offense of bribery together with the giver and the receiver.
Have you heard of a defense loosely referred to as a defense of entrapment?
My lady, not quite.
Where the position of the law is that the end does not justify the means. And so when we say the end does not justify the means, given the circumstances that I've given you, are you able to elaborate on that? The end does not justify the means.
Okay, my lady, probably I would need to
okay,
refresh on
evidence has been evidence has been adduced, but the way this evidence was gathered was as it were tainted with illegality. So just for the courts to discourage investigators from misconducting themselves, even if Mr. X received that money, the court should inevitably find him not guilty.
I'm well advised, my lady.
Thank you.
Thank you.
Thank you, Honorable CJ. And Wakili, once again, welcome.
Thank you, Commissioner.
We talk about education matters relating to children. And it's good that you have been in the constitution making process. You are actually one of those people who came up with the legislation to give life to the constitution. Thank you so much for that contribution to this country.
Thank you.
Article 53 of the constitution deals with the children, and sub-article 1B provides for the right to free and compulsory basic education, to the extent that every child has right to free and compulsory basic education. What do you think entails this basic education, this free compulsory basic education? What does it entail?
Great, Commissioner. Thank you. What basic education, by definition of the Act or by what the Constitution envisioned, and that's why it gave both pre-primary education to counties and primary education to national government. That is education up to a certain age, around 14 years, as basic education.
Okay, so, I mean, that if the age is 14, it effectively covers primary, both the junior and the normal primary and the junior secondary, age 14. What about senior schools? Is that not part of basic education?
Actually, sorry. Basic education covers everything, including senior school, that is high school, even currently. The entire Basic Education Act is a child up to the age of, not necessarily age, up to secondary. Secondary education. That is basic education, pre-primary, primary, and secondary, even with the changes in CBE.
Okay.
Yes.
Good. Now, there is something which has been with us as a country for some time. I think now it may be fading, but it's been there for some time. It's called or referred to as adult education. Have you come across that?
Yes.
Okay. What is it?
Adult education is where a person who, for different varied reasons, who is above 18 years, who seeks to sit for examination or undertake classes for purposes of obtaining necessary qualifications, whether it's KCP, KCSE, all the way.
Okay.
Yes.
Now, someone undertaking adult education, will that right be covered under Article 53 1B? Right to free and compulsory basic education. Can someone come under that act, under that provision and claim free and compulsory basic education?
Thank you, my Lord. The Constitution defines the age No, not sure it defines a child, but a child is defined also in the Children's Act. But a person above the age of 18 is not a child in the context of children under Article 53. So the basic education may be offered, but at a certain fee, because or whatever consideration that may be charged, but it's not basic education per se to an adult.
Now, having said so, I will take you to this act, one of these acts which you came up with on Article 53, where you define basic education to mean as follows: the educational programs offered and imparted to a person in an institution of basic education and includes adults' basic education and education offered in early childhood education centers. That's the definition of basic education, to include adult basic education.
Okay.
How do you marry that?
Okay, great. Thank you, Commissioner. Acts of Parliament, in terms of interpretation of terms in the interpretation clauses, have the power based on other contexts, because that law does not only apply to that element of education, it applies also to possibly matters of certification, matters of which institution they are going to be subjected to learning, and so on. So probably it overstretched the definition of not the child. What has been defined is basic education includes adult. That is, sorry if I got you right. That is what the Act says.
Yes.
It includes.
Yes, basic education includes adult basic education.
Yes. So it reaches out, it stretches out to that category, owing probably to necessity of that Act to cover basic education for adults in the entire scope of that particular Act, not necessarily defining an adult as a child.
Yes, as long as you want to take a primary and education and secondary education, the law provides.
The law you'll be bound by that particular law. Yes.
Now, if Article 53, I'm just coming to an end. If Article 53 was restricted to children, and the Basic Education Act expanded the provision of basic education to include basic adult education, which provisions of the Constitution or article do you think the parliamentarians took into account to expand that? Or to silently include adult basic education as part of basic education?
I think thank you, Commissioner. It read that Basic Education Act may have stretched that scope to cover also youth, Article 55, which actually says...
Part of 55, yes. Youth.
Yes, part of 65 that says that even
youth. Yes, next.
Yes, and also probably marginalized minority groups of persons in the who are categorized as such may reach out to that level. And then, of course, is it an article on... then, of course, purposive interpretation of the Constitution giving broader scope to cover a certain group of the community. And also, there's an article, I can't recall, on the...
What about human dignity?
Exactly, that's the one I was looking for, my lord. Thank you. Human dignity for persons who did not have exposure to education at the right time owing to certain challenges may have an opportunity to take on education so that they're able to uplift their lifestyles and so on. Equality
and there are many provisions.
Yes.
Thank you. I wish you the best.
Thank you. Thank you, Commissioner.
Yes, good morning.
Good morning.
Would I be right to say that your strongest professional career is in law reform and legislative drafting? How long were you at the legislative drafting department of the Office of the Attorney General?
Thank you, Honorable AG. I was at the AGs for close to 7 years, 6 to 7 years.
Then Kenya Law Reform Commission?
I served for 5 years.
As a vice chair?
Yes, and responsible for Law Reform Committee.
Thank you. Kindly, what do you understand by the term dead letter laws? I've seen you have a diploma from the, is it University of London, legislative drafting? So what do you understand by the term dead letter laws?
My lady, I'm not so sure unless I refresh, probably just a little bit of information on that, a little bit detail.
Have you heard of the term at all?
No, not the time.
Have you heard of the term obsolete laws?
Yes, absolutely. Archaic obsolete laws.
Those are dead letter laws.
Saying sorry.
Please, can you give us 3 characteristics of those dead letter laws or obsolete laws?
Okay, sorry. Thank you so much. Obsolete laws are laws that have since served their purpose, have been overtaken by event. Innovations have taken a place and changed the context. They are dead on the statute book and ought to be repealed in totality.
Now, there is a doctrine in law reform and legislative drafting called destitute doctrine.
Sorry.
Destitute doctrine, or in Latin, desuetudo doctrine. What do you understand by that?
Sorry.
It is basic doctrine taught in law reform and legislative drafting. When you have obsolete laws, how do they stop being effective? How do you deal with them? For example, in Kenya now today, I'm in charge of Law Reform Commission. We have about 18 obsolete laws we are working on. How else do they stop being in operation? So one way for them to stop being in operation is by non-enforcement or lapse of time, and that doctrine is what is referred to in Latin as desuetudo. Which other ways would they not come in? Would they stop being effective?
An obsolete law is already ineffective by just operating.
How do you remove them from the books? What do you do?
Repeal.
That's what I'm asking you.
Yes, my lady.
Yeah.
Yes. Thank you, Honorable AG.
I'm sure you know them because you are an expert in this area.
Probably it's because, yes, obsolete laws, my lady, I did indicate that for good reason they must be repealed and removed from statute book because they are unnecessary baggage. They are already serialized. These have no effect. Time has lapsed. So by operation of lapse of time, they cease to be
Would the promulgation of a new constitution render some laws obsolete?
They might have been rendered obsolete.
Can you give us some examples in Kenya?
The laws that were establishing institutions that have since been devolved, those laws, unless acts of parliament have been enacted, repealing them, they are still in force but not operationalized. Those institutions since devolved. So that to me is a law revision issue, a law reform issue, that we can have even an omnibus bill that actually declares all those laws or repeals all those laws, having assessed their transitional and saving mechanism to ensure that we do not have assets, liabilities, and other transitional issues left out. So it's one of the strategies.
I told you are an expert in the area. Now you agree.
Thank you, my lady. Thank you, Honorable Attorney General.
All right, thank you.
Yes.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon.
My name is Jacqueline Nguti. I'm a commissioner. You can have water. You know, it's a you know, the response you wanted to give AG is that seat is hot.
I know.
Things disappear at times.
Yes, thank you, Commissioner.
So just proceed and drink water. I'll wait for you to finish so that I can ask you the questions.
Thank you.
Okay, welcome. I've gone through your sample writing, Council. You have shared with us institutional guides, a thesis paper, consultancy report, and regulations, the IPOA regulations. They demonstrate clear issue identification, structured and systematic reasoning, internal logical coherence, and balanced professional tone.
However, I note that, say for this thesis paper, these other ones are co-authored by other persons. So we can't really tell your individual way of writing, including making reference to decided cases. Maybe you can speak to that.
Thank you, Commissioner. Thank you so much indeed. Those documents are what I could be able to give without going through the institutions I've worked to obtain authority to share. But also largely my experience has been in law reform, where I draft policies from the scratch. I draft laws from the scratch, creating structures or unbundling problems by various executive entities into legislatable and enforceable and also practicable solutions to their issues. Most of these documents, you can never claim ownership to them. You can't claim ownership to a bill, you can't claim ownership to a policy, because at the end of the day, it is indeed an extensively, highly involving process that many stakeholders have a take here and there. So I may not have given, but my years of experience in this sector, I assure you, I have done a lot of reports, and I've done a lot of laws, almost running to hundreds for both levels of government. So that tells you in terms of writing, in terms of comprehensive research, analytical skills, command of the Constitution and the law is evident in the documents that I have drafted. In fact, hardly as any of my laws, I can't claim ownership again because Parliament also passes those laws and county assemblies, but I hardly have they actually had a constitutional challenges because I have that mirror effect when drafting them, and also interpretative skills that are necessary to ensure there is no conflict. There is internal harmony in the statute and also in the entire statute book in the laws that I have drafted.
And how would that be beneficial to the judiciary as a judge?
Excellent. Thank you, Commissioner. Very beneficial. The fact that I understand how the laws are made, that is critical. The fact that I understand the mischief, the purpose of the instrument, the interpretation, the structures, both in the Constitution and in that particular law, that will go a long way in my interpretation of any issue before me. The research skills that I've had to own over the years will also go a long way. Writing, I write a lot. As a drafter, you must read a lot and write a lot, mostly appreciating diverse issues, bringing them together and being able to interpret them, and also translate them into documents that are implementable. I also look at the varied stakeholders that I've had to manage, having drafted the Kenya Defense Law, the NIS law, the police laws, actually the entire executive sector pieces of legislation. I've worked on them, and to date, they are still operational, and they're serving the purpose without major. So I think I have also stakeholder skills that are necessary in managing my court.
Okay, thank you.
Thank you.
Lastly, you mentioned that you participated in drafting laws both at the national and county levels, but they appear the counties appear to be replicating national laws, and the example I would cite is the Alcoholic Drinks Control Act. We have a national legislation around that, but counties are also coming up with similar legislation, and the other bit would be around health. So what is not happening in the country, and what can be done to address that particular issue?
Thank you, Honorable Commissioner. And indeed, when we came on, when having worked at Kenya Law Reform, at the initial stages, we looked at Part 2 of the 4th schedule and assessed what are the functions that are exclusive for the county government and came up with laws. Now, the problem is that we still have in our statute book national laws that are regulating the same issues that have since been devolved by the Constitution, making it a double legislation on the issues. Now, the challenge is what Honorable Commissioner Omanza did ask me about double taxation, duplication, and unnecessary disputes and conflict between the two levels of government. And again, if brought to this level, I'll be able to address, from the High Court, I'll be able to address the functional demarcation, even if it calls for declaring certain national pieces of legislation and constitution or county legislation and constitution to the extent that they are overreaching, their scope as allocated by the Constitution.
Okay, I'm okay with that response.
Thank you.
And all the best.
Thank you, my Honorable Commissioner.
Two questions.
Yes,
the first is, on what basis can a county boundary be amended, and what is the process for doing so?
Process. Thank you, Honorable Commissioner, my lady. There is if you look at the chapter on elections and the role of IEBC and how
It's not IEBC.
Sorry, I know that's IBC, it's on delimitation of constituencies and the like. So county boundaries is a parliamentary process in totality, allowing they can come up with a motion subjected to public, but a bill subjected to public participation, and if it's so that approved, then it actually can be.
Where is that bill generated from?
I can't remember the
Okay,
article,
that's
my
fine.
lady. Though, sorry, if you allow me, the Constitution also further says in Article 255, one of the areas that cannot be touched until a referendum is actually issues of object, principle, and structure of devolution. If we stretch that interpretation of structure of devolved government, then we might be touching on issues of boundaries of counties, and as such may require a referendum. That's if it's interpreted to mean that the object and structure of devolution is actually being touched by that. Thank you.
Although there is a specific provision, article,
Yes, I
on
think
that,
it's
on
bound-
that,
188.
on delimitation of county boundaries, you'll find it in the chapter on devolution, which talks about counties. But I don't want to belabor that point. Let me bring you to jurisprudence of the Supreme Court. If you can answer, I'm going to ask you three questions. They are all interrelated. What is the difference between a mandatory and minimum sentence? Can you give me an example of each? And can you cite any case law from the Supreme Court which dealt with this issue?
Thank you, my lady. Mandatory sentence, the Moratetu case comes to mind, having been involved in the task force and coming up with parameters as advised or required by the Supreme Court. Moratetu is an example of a case that was dealt extensively, both 1 and 2, by the Supreme Court trying to demarcate what exactly mandatory death sentence, mandatory nature of death sentence was declared unconstitutional because it took away the discretion of the judge or judicial officer to determine on the basis of mitigation and other factors, if indeed, or other aggravating factors and so on, if indeed mandatory sentence, nature of death sentence. But it did not eradicate or remove the death sentence in our statute book. It remains there. Minimum sentences have been set in various legislation, including in EMCA, Environment Law, Sexual Offences and Sexual Offences Act, and even a penal code. Now, what happens is that the minimum sentence, you cannot go below that which has been set by the law, but you can. There's a flexibility, so the judicial officer has a leeway to either over and above the minimum sentence that has been set by the law, based on aggravating factors, increase the same, but cannot decrease. Mandatory, no other option other than going by death sentence that it is, and the Moratetu explained, including providing for issues of parole, which still we have not provided for them in our statute book. And I hope, seated here, given an opportunity, we should be able to compel Parliament to come up with a parole system that addresses those issues of sentencing the offences of murder.
What do you think is the purpose of minimum sentencing?
So the purpose of minimum sentencing I want to imagine that Parliament says any right can only be limited through legislation. Let's start by that. And one, if we have to prohibit, to deter in totality, then something must happen. It has to be so serious that you can never go below this because of the threshold or the magnitude of that particular offense, impacting the society, probably even to victims and so on.
Okay,
Yeah.
thank you.
Thank
Well
you, my
answered.
lady.
Thank you.
Thank you.
Thank you, Chair. Good morning once again.
Good morning, Madam Commissioner.
You are currently a practitioner.
Yes.
Okay. Are you a member of any CUC or bar bench?
Thank you, Commissioner. Now, at the moment, none.
Have you attended any of their meetings?
Not at all, because I'm embedded in an institution, a COG, where I'm not engaged totally in court matters.
So you're not practicing?
I'm a consultant.
Okay.
Yes, my lady.
I want to give you a scenario, and then you can tell me what you will do or how you will go about it. So you are successful, you've become a judge of the High Court. And on your first day of work, you have a case before you for plea. It's a murder plea. The accused is a child of 7 years, has been charged with murder. What are the steps you will take in proceeding with the matter?
Okay. Thank you, Madam Commissioner. First, a 7-year-old is incapable of committing a criminal offense of that threshold, much worse. And even if they were, of committing a murder, and therefore even the law exempts them from category that can be charged below 8 years.
Is it that the law exempts them, or they're incapable?
They're even incapable of comprehension that indeed that is murder they have committed.
So they may commit murder, but it's the law that absolves them of criminal responsibility.
Both law and their nature, their age, they are not even able. I think it's studies that have been carried out to establish that a child below 8 years is nearly incapable of knowing what they are doing, particularly committing murder.
Okay.
Yes.
I'll take that. Thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Doreen.
Thank you, Commissioner.
Now, what is the responsibility of a judge in respect to social media activities?
Great. I presume, Madam Commissioner, that this is in the judge responsibility around social media, how they use their social media, and not necessarily dealing with the matter with regard to social media.
How do you interact with the social media as a judge?
Exactly. Thank you. Actually, I looked at the code of conduct for judiciary, judges, judicial officers, and other staff of the judiciary, and others. Sorry. Yes. First and foremost, a judge should not in any way post or comment on matter that they are handling. The social media is here to stay, and people, judges and every other person may in one way or from time to time engage in it. It's a way to reach out to your stakeholders. It's a way for the judiciary to access the litigant and other stakeholders that are in one way or the other seek justice in court. As a judge, you may maintain your page, but you cannot engage in matters that are controversial to the extent that your judgment may appear impaired, or comment in a matter that is likely to show up in your court the next day, where you are actually obligated to look at it, and therefore there will be conflict in terms of what your perception is on the matter. Social media engagement, decent, professional engagement on social media is also important, because absence or blocking yourself from access to social media may also be a danger to yourself. You may not know what is happening the world over. It is a forum for information, to learn and to exchange and even to unwind. Sometimes it can be hectic for a judicial officer to just sit and not engage with others in social media. So I think it has to be disciplined, contained, regulated, and the code also speaks to how much one can interact. Then the structures of communication, in case of anything that you need to be communicated from a judge point of view, it has to be communicated through the chains and the structures set out. The Chief Justice and the office that is responsible for outreach should be able to deal with that particular issue.
Okay, thank you. I wish you all the best.
Thank you, Commissioner.
Thank you, Honorable CJ. Wakili, I have 2 questions for you.
Thank you, Commissioner.
COVID-19 introduced a new way of doing things all over the world. Maybe you could tell us some of the new ways of doing things came up during this period, and what risks you think the judiciary will face or is facing due to this.
Okay. Thank you. COVID-19, thank you, Commissioner. COVID-19 brought about the necessity to stay away from physical interactions, social distancing and the like, forcing every other institution, including government and state organs they are under, to create forum where they could offer their services without physical interaction. So physical courts were removed, and then we have automation to provide for this.
How have you prepared yourself for this role, if you're successful to become a judge, that you will not have any control over where you're posted? Because I note in the previous roles you've majorly been in the city. So how have you prepared yourself in the event that you're posted in a place like Busia or Lamu?
Thank you, Madam Commissioner. How I have prepared myself, this is a personal conviction, having served throughout in this legal sector, law reform, drafting, constitution, human rights investigation, holding accountable officers as they carry out their duties. So this is an area I'm quite familiar with. And I have prepared myself mentally, if given, and I'm praying that I'm offered this opportunity, I will serve diligently in support of the Chief Justice and this Commission in realization of the STAG pillars. And additionally, I can work anywhere in the Republic. I joined as a state counsel. I had no idea where I would be posted. When I was posted as a state counsel based in Nairobi, I settled here in Nairobi, but that did not mean if I had been posted elsewhere, because I really wanted to join prosecution's department. Then AG and DPP was one and the same, and I did not have a challenge with that, Honorable Commissioner. So I'm here willing to serve. That's why I've offered myself, having gone through all those institutions in public service. I think this is my calling, my conviction, and I pray and hope that I'm given the opportunity.
Okay. I'm looking at your profile. A lot of positive things have been said about you.
Thank you.
Good to know that they did not leave out your sense of fashion.
Oh, thank you.
That you're detailed in your dress code, and you emphasize on appearance, always putting on a tie. That's a good thing. Do you have a weakness, maybe, that has not been put out here?
Oh my God. Thank you, Commissioner. And indeed, it's true. I think I'm too keen on detail. I am extremely keen on detail. Sometimes it may appear like I'm too much on certain people. I'm also very focused. When I want things done, I get them done. In fact, if you ask my colleagues who you want things done, then just call Muthaura. Muthaura will get things done and done correctly. I have upheld integrity throughout my working life in all the institutions I've been. If it's a weakness, it's just being too firm, focused, and keen on detail. I am. Thank you.
I hope you manage the interpersonal relations that come with the friction.
Yes.
Due to your strictness.
Yes, Madam Commissioner. I have, and sometimes I just have to relax and allow the other person to be, because we are not of the same strength, neither are we able to catch up at the same level. Okay. So I've had to accommodate others, and then mentoring others so that we walk together the journey. I delegate with meaningful delegation and supervision to allow the other person also to catch up and get to the same level.
Okay. Thank you, and I wish you well.
Thank you, Madam Commissioner.
Thank you. Now, with the number of years of work experience, what has been your biggest professional challenge, and how did you overcome it?
Thank you, Honorable Vice Chair. The biggest challenge is being drawn from back office as a reformer to going straight to deep end to deal with the NPS. That is a big challenge, I assure you. Recently, I saw one of leaders in one of the institutions I worked for leave because that entity requires you to literally self-evaluate and be able to understand them because their terrain is not the same as ours. The systemic challenges there might actually drive you from oversight point of view almost crazy. So that challenge, we had to sit with the stakeholders in both sectors, agreed on our working modality, and we called it cooperation and collaboration. That's the only way we were able to move from 3 conviction to 20, almost 20-something conviction. I know conviction to them is wrong. We shouldn't have conviction, but our success rated from an oversight is how much reform you've been able to impart in that institution and also the number of convictions. So I think it's a huge challenge. I cannot delve into the details, but it is